Right, morning everyone, and welcome to today's webinar. If you are joining us again for this webinar, then welcome back. Today we're going to be looking at the consequences of tax immigration. I'll be your host today. I've got over 10 years in the accounting and tax field, and I'm predominantly in tax and international tax matters. We also have Dave on the line. You might not hear a lot from him today, but he is in the background. Dave's got over 25 years of experience as a tax practitioner, and over 6 of those years were with SARS as a senior auditor. Sorry, cool. Some of the topics that we're going to be covering today is we're going to look at South African tax residency. So how do you determine your tax residency? We're going to have a look at when you need to look at the double tax agreement, and we're going to just assess part of the UK and South African double tax agreement. We're then going to look at how do you break your tax residency, so the timing of such, how do we notify SARS of breaking our residency, and then a deemed disposal. We're then going to briefly touch on pressure that SARS is putting on expats, withholding taxes, and then briefly on retirement funds. Whilst we are going to go through a lot today, just to make specific mention to the fact that tax residency is a very complicated topic. So a lot of the advice that we're going to share with you today is general and broad advice. A lot of the times there is specific legislation and further legislation that needs to be dived into, and it really does depend on individual circumstances. So going straight into it, if we have a look at the residency in South Africa, South Africa is a residency-based tax system, which means you are taxed on your worldwide income if you are deemed a South African tax resident. And one thing to make specific mention to is tax residence is not the same as physical residence. So you might be abroad and you could still be deemed a South African tax resident. And this is why you have to go through the local law tests for both jurisdictions to determine your tax residency status. So in terms of South African residents, there are 2 tests that we need to determine. These are mutually exclusive tests. So we'll go through how to assess those. The first test is an ordinarily residence test. Now, the term ordinarily resident is not defined in South Africa, in the legislation in South Africa, but there is an interpretation note by SARS, which does provide guidance. There's been more than a century of dealing with this guidance, and so there is a lot of case law around this matter. Effectively, what SARS is going to look at to determine your ordinarily residence is if you are going to return to South Africa after your wanderings. So if you, let's say you've got a job overseas and you're wanting to go overseas, and let's say it's a year contract, and then after that year you get a further contract, and now it's 2 years, 3 years, 4 years, and then you come back to South Africa, you might still for all of those 4 years be deemed South African resident if you have returned from your wanderings and come back to South Africa. So it's quite important to note that there is no time frame. This could be 15, 20 years. SARS is really going to assess a lot of factors to determine whether they believe that you are actually going to return to South Africa after you've now traveled the world or wherever you may have been. So when assessing your ordinarily residence, this is a subjective test, meaning that the onus to prove this is upon the taxpayer. So SARS can only really make their assessment based on the facts that they have on hand. So a lot of the time, let's say someone would have gone overseas and now it's been 10, 15 years and they're wanting to assess their residency. It's quite hard for them to try and have proof to indicate that, when they left 15 years ago, that they actually ceased their ordinarily residence test. So it's really important that when you are assessing your factor, the different factors, that you are noting it, whether you are emailing a residency consult specialist, whether you are documenting all your evidence. It is quite important to have that, because that is going to be your proof. If you don't have documentation, you really don't have anything to stand on if SARS were to audit you, and you need to then come and justify why you believe you ceased your residency via this test. Some of the factors that SARS are going to look at is your intention. So when you left, what was your intention? Bearing in mind that intention can change, SARS is aware of that, but just to make a note that when you do leave, what is your intention? Short-term, long-term, unsure, and then at what point would your intention change after 1, 2, 3, or however many years? Document that as well. They will then look at your most fixed place of settlement, your habitual abode, which is basically how many days you've spent in each different jurisdiction, your place of business and your personal interests, your employment and economic factors, your status in South Africa, and then in the other countries, do you have citizenship or passports? All of those things. Maybe you've got an ancestral visa, so I was just going to have a look at all of that. Where are your belongings located? And this might sound silly, but it can literally be down to you've got a bed at your parents' place. So it's quite important, because SARS is going to look at each and individual factor. Your nationality, family and social relations, political, cultural, other activities, your periods abroad, so where you have been, and if you have been traveling, what was the purpose of those travels, and then the nature. And then if you are returning to South Africa, you are allowed to return to South Africa once you formally exited. There are provisions around timing, but ultimately SARS is going to want to understand why you're coming back to South Africa, and then your frequency of those visits and the reasons. Just to give you a bit of an example, we have dealt with a case before where someone had thought they had ceased residency by leaving South Africa via ordinary residence. They had immigrated, they didn't want to return to South Africa, they didn't return to South Africa, they hadn't done this assessment, and they still had gym contracts in South Africa, as well as not only bank accounts. You can have bank accounts. I suggest just having one, unless there's a commercial reason as to why you have multiple. But they had a gym contract, and they also had medical aid in South Africa. That really is factors that SARS can fight for, because they can indicate, well, if you're going to have medical aid and you're going to have these gym contracts, it seems like you're going to return. So if you are intending to leave, make sure that everything is settled, everything is cancelled. There might be a small time delay while you are over in the new country, but make sure that all of that stuff is up to date, and it's noted as well. Keep a record of that. So that would be the first test. If at any point during the year of assessment that you are assessing, you are deemed not to be ordinarily resident, so you assess these factors, you then have to go through the physical presence test. Now, this test is not subjective. It's looking at the number of days, so it's quite straightforward. And there's also an interpretation note on the SARS website that can provide further guidance on this. But essentially, you have to meet each criteria here. So there's 3 points. You have to meet every point in order to be deemed physically present in South Africa. So the first point is you need to be in South Africa for a period greater than 91 days in that year of assessment that you are assessing. The second aspect is you need to be in South Africa for a period of 91 days for each of the previous 5 years of assessment. And then the third aspect is you need to be in South Africa for a period of greater than 915 days in aggregate during those previous 5 years. Now, if you're just hitting the 91-day mark for point 2 for the previous 5 years, you're only going to get to about 460, 455 days in South Africa. So you actually need quite a few more days to be meeting point 3. Also bear in mind that these days do not have to be consecutive, so they don't have to be, for specific for 3 months at a time. You can come and go. If you've got 91 days in that year of assessment, you're going to be meeting point 1 and point 2. So if you are deemed a resident by virtue of this second test only, so by the physical presence test, your residency will cease when you are physically out of the Republic for a period of 330 days. So that's called the continuous period is called 330 days test, and then residence will then cease from the day that you actually left the Republic. Okay, it's quite important in terms of the date that you exit or cease your residency in South Africa, because it does trigger tax consequences. Something to bear in mind is just because I hop on a plane today and I leave South Africa with no intention of returning, does not mean that my residency is broken today. I have to assess it because I've got to meet that 330-day rule, as well as I need to ensure that I've assessed the ordinary residence test. So just because the date you leave does not always mean that that's the date that you cease in your residency. You have to assess these factors. We're going to go through an example now, because it can be quite hard to understand the physical presence aspect. So let's have a look at this example, and this is also from the interpretation note 3, so you can have a look at that. Sorry, the interpretation note 4, so you can have a look at that for the detail around this example. But effectively, let's say Jane is a citizen of Argentina, and she has got employment in South Africa. And she was first employed in South Africa from the 29th of June 2011, and she was not in the Republic before this date. So what we're trying to assess is her residency for 2017. We already note that she's ordinarily resident in Argentina, so we need to assess her physical presence in South Africa. And these days are the number of days that she's been in the Republic from 2012 to 2018. So if we have a look at the first factor, which we're assessing, which is she needs to be in the Republic for more than 91 days in the relevant year of assessment. We can see for the relevant year of assessment, we've got the 17 and 94 days. So we're getting to 111 days here. So we tick point 1. Okay. Second point is she needs to be physically present in South Africa for greater than 91 days in the preceding 5 years. So in 2014, we've got 2012, sorry, we've got 246. 2013, we've got 92. 2014, we've got 181. 2015, it's a combination of these two, we get 195. And 2016, we get 244. Okay, greater than 91 days in the preceding 5 years, tick for point 2. The third point is, was she in South Africa for more than 915 days in aggregate in the preceding 5 years? If we tally up this total, we get to 958, so tick point 3. Okay, so all the requirements for the 2017 year of assessment are met, and she's therefore going to be deemed a South African tax resident by virtue of meeting the physical presence test in South Africa. Now, despite she was only in South Africa for the 2017 year of assessment from 29th of June 2016, her residency for the 2017 year of assessment begins from the 1st of March, the start of the tax year of assessment. She'll be resident for the full 2017 tax year of assessment. Okay, so that's quite important. Now, the next thing we want to assess is we can see that for the period after 30th of November 2016, so for the period 1st of December 2016 up until the 31st of October 2017, she was out of the Republic. And for 2018, she was only in the tax year in South Africa for 30 days in that tax year. So during this period here, okay, that December 16 up until October 17, she was out of the country for 335 days. Okay, and that was a continuous period. It has to be continuous. That means that she's met the 330-day rule. All right, so what we can do then is we backdated her cessation of residency to her original date of departure, being 30th of November 2016. Which means that Jane ceases to be tax resident in South Africa from the 30th of November 2016. Okay, it's one of the things with this is, and we're going to go through the section 9H capital gains exit charge. But one of the things with this is you can see that you have to meet this 330-day rule, which means that if you do cease your residency by virtue of this physical presence test, and you can only really assess 330 days later, provided you've remained outside of South Africa for those days test, which means that your residency then is backdated, which means that on the date of exit, you have this exit charge, and we'll go through that in more detail. But what it does is it changes your year of assessment with SARS. And we know that from provisional tax that you'd have to pay your specific provisional tax by that year of assessment. We're getting to a point where there might be interest and penalties on this. So although this does seem unfair, a lot of assessment has to go into this to determine what could the potential tax liabilities be, and also that people need to be doing this or assessing this prior to departure out of South Africa to ensure that they've got the necessary cash flows to pay these exit charges if necessary, as well as to assess the actual year of assessment. It's also going to affect your tax consequences in the other jurisdiction that you're going to be in. All right. So bearing in mind, with this breaking of the tax residency, the days test, which we spoke about, the 91 in the previous 5 years and 915 days, need to be met in order for you to be physically present in South Africa. Okay. Now, if you deemed resident by virtue of the days test, then it's very important that if you do return to South Africa in the following year, okay, then you can't be in South Africa for more than 91 days, because then you're getting to a situation where you're meeting all three criteria again. Okay. And also in this situation, you wouldn't meet the 330-day rules if you're going to come back. Okay. So as an example, let's say you leave South Africa in December 2021, you deemed to be tax resident for the 2022 tax year by virtue of the days tests, and now you want to return to South Africa for a holiday in the 2023 tax year. Okay. So bear in mind, to break your residency, you need to be out of South Africa for 330 days from December 2021, and then you can't come back in that following tax year for more than 91 days, because if you do, then again you meet point 1 and you meet point 2, and you're potentially meeting point 3 of the 915 days, so your residency is not broken. So if you are going to be returning to South Africa each year for a holiday, or you've got work, or for any reason, you need to apply the days test for each year of assessment. Okay. Now, what happens with a double tax agreement, and when we use these double tax agreements, is if you are deemed a South African tax resident, okay, by the local laws test, which we've spoken about, ordinarily residence and physical presence, okay, and you also meet the local laws test in the other jurisdiction as a resident, then you're now grabbed by both jurisdictions as being tax resident. Okay, now you can, yes, in some circumstances have dual tax residency, and you would follow the double tax agreement if there is one. Okay, and in the double tax agreement, there are tiebreaker rules. Not all double tax agreements would have the tiebreaker rules, but they would then provide reasoning on how you would claim the tax relief in each jurisdiction to ensure that you are not paying double tax. If you are going to a country where there is no double tax agreement, you might then not fall within the safety net of not paying double tax. So there is that consideration to make. And so it's also important to ensure that if you haven't left South Africa and you have leeway to determine when you want to leave, then you actually approach someone to see what sort of tax consequences there might be in the other jurisdiction, because you could still be paying double tax. All right. When I mention double tax, I'm not saying just because you've paid tax in South Africa doesn't mean you're going to pay tax in the other jurisdiction. Very simply put, if South African's tax rate, if you fall in, let's say, the 41% tax category, and you've paid 41% in South Africa, and in the other jurisdiction the tax rate is 45%, okay, you're going to pay 4% more because you're going to be paying the higher tax. Okay, so there would be 4% tax payable in the other country. You would get a relief for the 41%, but they might still be taxed. It all depends on the tax rate of the jurisdiction that you're going into. Okay, so if we assess this from a UK perspective, so let's say someone's now immigrated, they've gone to the UK, they've assessed their South African tax residency, they are deemed a South African tax resident for that year of assessment, they've had a look at the UK tax legislation, they are deemed a UK tax resident in that jurisdiction, they're grabbed by both jurisdictions as being a taxpayer. So what we do is we go to the double tax agreement. Okay, the double tax agreement between the UK and South Africa, they do have tiebreaker rules. And if we have a look at the clause below, we can see what we do is we then start assessing. So where by reason of the provisions of paragraph 1, which is just talking about residency, okay, an individual is resident of both contracting states, being South Africa and the United Kingdom, then that individual's status for residency shall be determined in accordance with the following rules. All right, so the rules that we're looking at here are, and we don't assess all of these, so you don't have to meet all of these criteria to say, okay, I'm resident in that country. We start with A. If you can assess your residency by point A, then you leave B, C, D, you walk away. You've now assessed your residency. If you still can't identify your residency after going through A, you go to B, and you keep going all the way till D. Okay, so in this situation, let's say we've got someone who's residency in both. We're now assessing the tiebreaker rules. So the individual shall be deemed to be resident solely of the contracting state in which a permanent home is available. Okay, now permanent home does not mean that you have to actually own the home. If a permanent home is available to you, whether you rented it, whether there is family where you can stay, or you're renting in the other jurisdiction, then a home is available to you. All right, okay. If you can't assess it based on that, then we move to point 2, and point 2 is you will be deemed to be resident solely of the state in which the individual has habitual abode. Okay, so we're now looking at where you spend most of your time. Okay, so if you've spent most of your time in the UK, your residency would push towards you being a UK tax resident. If the majority of that year was spent in South Africa, it would push towards being in South Africa. Okay, that one is quite tough because just if you've got a couple of days out, so you half South Africa, half UK, it doesn't really say, okay, well, you habitually abode, it's sort of equal. So it needs to be a large chunk of that year being in that specific jurisdiction in order to meet that. Okay, if you've got a habitual abode in both of the states or in neither of them, because you're now 50-50, then you're going to be deemed resident solely of the state in which the individual is a national. Okay, if you do have citizenship in both jurisdictions, you would then go to point 4, which is where, and I haven't seen this before because generally you can assess your residency by A, B, and C. So if you still can't determine your residency, you would then have to contact the authorities, and the authorities by mutual agreement will determine where you are resident for that tax year. Okay, like I said, I haven't seen point D in action ever, and I'm not sure how that would actually go about contacting them to get this sort of agreement. But most of the time, in all the cases I've seen, you can assess your residency by going through A, B, and C. All right. I've kept this page in, although you can't see much. If you are returning for the this webinar, you would have previously, I would have done spoken about this slide where you could break your residency on the actual tax return form. This on SARS's website, it still says that you can break your residency through the tax return. This is no longer valid. SARS has actually removed this completely. So you can't break your residency by notifying SARS on the tax return. You've got to go through the other channels. What I do need to note though is on the tax return on the wizard form, you can still complete if you're completing the tax return as a non-resident, which is still obviously vitally important. If you are non-resident, you would need to tick that box. Okay, but this box has been deactivated, whether it's grayed out, don't worry about it, it's not relevant anymore. Okay, so in order to break your tax residency, there's two ways. It leads to the same end point. Either you go onto the RAVO1 form on e-filing and you update your residency status there. What happens is it sparks a letter from SARS. You'd have to then download this form and you upload all your documentation to SARS on e-filing. The other option is you don't go through e-filing, but you complete this form and you submit this form to SARS with all the relevant documentation. Okay, the previous one with the big X, there was never any formal clarification from SARS whether they accepted your residency. With this aspect, there is formal notification. SARS will issue a letter and they will state whether they've accepted or declined your residency. This declaration to cease to be a tax resident form, it asks for a lot of information, and then it asks, how did you cease your tax residency? Now, we've spoken about the three ways, either by ordinarily residence, either by physically presence test, or thirdly by the double tax agreement. You're going to need to stipulate which one is how you broke your residency. It's going to be very important that you have sufficient proof and sufficient evidence of how you've come to your conclusion of how you've broken your residency, because SARS is going to ask for it. So you need to make sure that you've assessed it correctly. You need to make sure that you've looked at the legislation. If you've had to go to the double tax agreement, you need to make sure that you're showing SARS that you've gone to the double tax agreement because you've looked at the local laws tests in both jurisdictions. Okay, so there's a lot of assessments here. If you are unsure, then get in contact with us and we can assist with the assessment of that. For this form, this is just one aspect of it. There are going to be other documentation required when you submit the form. Okay, so it's the signed declaration, which is this form, as with all the points. You're going to have signed that. You're going to have a letter of motivation. Now, this is exactly what I was saying. You need to set out the facts, the circumstances, details supporting why you have ceased your tax residency and why you have specifically indicated one of those three cessation points, how you've come to that conclusion. Okay. Copy of your passport and travel diary. So make sure that when you're uploading this to SARS, you've got your front page, your back page, and the date of when you actually, the stamp showing your exit out of South Africa. Okay, in addition to the above necessary information, if it's applicable, you're going to include the following: the type of visa which you've gone to the foreign country on, or if you've got another passport, then you're going to upload that. Where you've already taken up permanent residency in that foreign country, you're going to submit proof thereof. Certificate of tax residence from the foreign authority, okay, or a letter stating that you're regarded as tax residents in that country. Okay, this is very important if you break your residency by virtue of the double tax agreement, okay, because if you're breaking your residency by virtue of physical presence or ordinary residence, you would most likely be doing this, I would hope, soon after you exit South Africa. If you're breaking it via double tax agreement, you've obviously assessed both jurisdictions, the local laws tests in both jurisdictions. So you would be deemed a resident in that other country, can make an application in that other country for a certificate of residence. SARS is going to ask for it. Proof that you're submitting tax returns in that other country, whether you have a tax number in that other country, whether you've got a tax return in that other country, SARS is not going to accept it. You need a specific letter from those tax authorities indicating your residency has ceased, or a certificate of residence for that other country. Okay, if you've got any property in South Africa, you're going to need to indicate to SARS the type of property that you have, whether it's rental, investment, or your was your primary residence. You're going to note that to SARS. If you've got any business interests, if you're still a director or a shareholder, you're going to need to note that to SARS as well. And that brings in a whole nother webinar where we will one day chat about companies and the residency of that once you've left. Okay, details of your family. SARS wants to know every single family member that you have in South Africa. They're happy with you to limit it to direct family, so parents, siblings, children, but you're going to need to note that you've got parents, where they live exactly, and the reason that they're in South Africa. Social interests, if you've still got gym contracts, recreational clubs, if you're still contributing to an RA, if you've got medical aid, you're going to note that to SARS. If you've got any personal belongings in South Africa, you're going to note that to SARS. And then if you're doing this after you've left South Africa and you're having to backdate this, then you're going to have noted to SARS the detail of any return visits to South Africa, the frequency and the reason for the visits back to South Africa. Okay. And then again, it mentions a tax residence certificate from that foreign country. All right. Now, when you exit South Africa, what happens is once you've assessed the date of your exit out of South Africa from a residency point of view, you will have deemed to have disposed of your worldwide assets, okay, per Section 9H of the legislation. Excluded in this deemed disposal is your South African immovable property. Okay, so if you do have your primary residence in South Africa and you leave without selling it, it's fine. It's not going to fall within this within this legislation. That's going to be taxed under the source rules. When you eventually sell that property, it's going to still be taxed in South Africa. Okay. This is super important. It can be super tricky depending on your assets that you do have. So if you would like an assessment on this, please contact us. But it is very tricky when it comes to if you've got business interests, whether you've got business interests in a listed or an unlisted company. There can be a lot of legislation that needs to be dissected in order to determine whether that's going to fall within the scope of this. Okay, so the deemed disposal is going to happen on the day before you cease to be resident, okay, and then you reacquire it, okay, at the day you cease to be resident, and whatever you deemed to dispose of it as is going to be the new base cost, and you're going to acquire that in your new country's currency, okay. So if I've left to the UK, I've had a deemed disposal, I've noted what the proceeds are, my base cost, I'm then going to reacquire it in pounds on the day that I cease to be resident. Okay, there's no definite answer to the day, but looking at guidance, it shows that it can be the day that you step onto the plane. Okay, but there's no case law around this. So again, this is a subjective test. Okay, similarly, what we spoke about earlier, the year of assessment will deem to have ended prior to the cessation and have started on the next day. Like I said earlier, this is very important from a provisional tax aspect, and interest is going to be issued to SARS on late and underpayments. Okay, so let's go through an example so you can sort of see the timeline of everything. So John's immigrating to the United Kingdom. He leaves South Africa on 28th of March 2020. He has a job starting in the UK a month later. He owns a UK rental property and he has a primary residence in South Africa. It's been on the market for 4 months. He's got no intention to ever return to South Africa. All his family and all his relatives have left South Africa, and he's gone through the steps of determining his ordinarily resident status. He's confident he doesn't meet that test. Okay, and let's say from a UK aspect, he's not deemed a UK resident. So we're going to ignore the double tax agreement, and we're going to look at, he wouldn't have been physical present in South Africa because he leaves on the 28th of March. So we're going to say that this is when he ceased his residency. Okay. So John doesn't meet the ordinarily residence test. So we must move to step 2, which is the physical presence test. He leaves South Africa on the 28th of March. He's only in South Africa for 28 days. He does not meet the physical presence test. He hasn't returned to South Africa. Okay, so we know his residency was broken on the 28th of March 2020. He's deemed to have disposed of his worldwide assets the day before his residency ceases, so on the 27th of March, and he reacquires those assets the day that he steps on the plane, which is the 28th of March. Okay, as his South African property is immovable, it's excluded. Okay, however, John will have to declare the UK property as a capital gain on his 2021 tax return and pay those taxes over to SARS. Okay, now the deemed disposal is triggered on the date that he left. Okay, the day before is effectively the date that he's deemed to have disposed his worldwide assets. His year-end zero assessment will be this 28th of March, okay? Because you'll backdate it to the date of his original departure, provided he was out of the country for 330 days. All right. What we need to remember here is consider the second provisional tax payment for the deemed disposal, okay, which is payable by the 28th of March. He would have only assessed the 330-day rule after this date, okay? You can assess it earlier, but SARS is not going to, there's no proof that you're not going to return within 330 days. There might be a need to do so. There might be an emergency. So you'd need to wait that period in order to then assess this. So by failing to pay this capital gains tax at this point, is going to mean that there could be potential interest and penalties. Like I was saying earlier, it seems like an unfair situation, but this is the legislation. Okay. If we're going to briefly look at the last 3 points. Okay, so there is quite a lot of pressure on expats, especially when there was an influx of South Africans leaving the country. SARS is of the opinion that many expats are probably non-compliant, either because they haven't ceased their tax residency formally in South Africa, they haven't filed tax returns in South Africa if they were meant to, and they haven't declared foreign income if they are South African tax residents. SARS legislation can punish these taxpayers if they don't engage and comply with SARS, okay? And taxpayers can be punished for non-compliance, either because they're not cooperating with the SARS official, or they're submitting false or incomplete documents, they're neglecting to notify SARS of their change of personal details. So if they have left South Africa, there is obligation to update those details with South Africa, and they haven't retained the records as required under the Tax Act. Okay, this is not a complete list, and SARS is willing to go the prosecution route to punish taxpayers, and there can be fine or imprisonment of up to 2 years. One thing to note is we have had a situation where people have been notified SARS that they're going to be issued a summons, and there's no way for that summons to be issued because that taxpayer is not in the country. And when that taxpayer arrives back into South Africa, the summons is issued at the airport. So SARS is not taking this lightly. Putting your head in the sand, not going to work. SARS does know a lot more than you think. So it needs to be a lot of attention paid to this if you are an expat. Solely being abroad does not exempt that person from declaring their worldwide income. So like I said earlier, just because you are living abroad doesn't mean that you don't meet the residency tests in South Africa. Unless you've formally exited and ceased your residency in South Africa, you're still going to be seen as a tax resident. Okay, the onus remains with the taxpayer to declare and formalize their residency status with SARS to avoid being prosecuted due to a non-compliant profile. If you haven't informed SARS of your exit, then they have the right to assume that you're tax residents in South Africa. And they have access to your South African ID. They have access to your South African tax number. If your tax number pops up as inactive or incorrectly coded on their system, then they can demand that you pay tax. There is something that is rare, but it is happening in South Africa. It's called jeopardy assessments. So these are assessments that can be issued by SARS to a taxpayer at any point. These are generally issued by SARS if they receive some sort of information or detail that a taxpayer is placing assets outside of their collection power, okay, or where a taxpayer is leaving the country, about to leave the country, or has left the country. Okay, and these jeopardy assessments can be costly. It's SARS just assessing you based on what they believe your income is. And then you're going to have to fight that. There'll be interest, there'll be penalties, potential legal fees, potential professional advice fees. So the advice is just when you exit, or if you have exited and haven't done this, just formally cease your residency with SARS in the correct manner. So in terms of withholding tax, so withholding tax is a final tax. It's not a tax that you can reclaim, and it's levied on non-residents. Each source of income has a different withholding tax rate. Okay, if we have a look at dividends, so dividends are subject to 20% withholding tax in South Africa, and then that net dividend is then paid out to that non-resident shareholder. Okay, one of the things is if you are a tax resident in another jurisdiction, but you also hold assets in South Africa where you are non-resident, read the double tax agreement. Okay, you can find all the double tax agreements on the SARS website under the legal counsel form, legal counsel tab, and there will be two tabs, one for South African countries or African countries and one for the rest of the world. Okay, read the double tax agreement because that will stipulate the percentage on which to withhold the tax. Okay, this is known as double tax agreement relief. And if you have dividends, okay, in South Africa, which are subject to 20%, and that double tax agreement says, you know, foreign dividends are subject to be withheld at, let's say, 10%, then you could get a 10% tax relief. So those dividends would be taxed at 10%. Okay, you have to assess it. SARS is not going to do it for you, but you can't apply it until you've made an application to SARS. So you assess it, you complete the form with SARS. SARS then accepts it and sends you a form. You then send that form to the company that's withholding that tax, okay? And they will then withhold the tax at the correct rate determined by the double tax agreement, okay? Again, the forms can all be found on SARS's website, and once SARS has approved and verified the percentage, then you can get that withholding tax reduced according to the DTA. Each double tax agreement will have a different rate, and this can apply to royalties, property, and interest. So have a look at that if you do have South African assets and you are non-resident. Okay, the final aspect that we're going to go through is retirement funds on immigration. This is new legislation. We haven't yet had the 3 years, so there is no case law. So I can only provide information of what we've read in terms of the legislation. Obviously, once we've met the 3 years and there is potential case law, then we can provide more detail. So rules have changed that the lump sum on your retirement funds is only going to be paid out after 3 years. So this impacts your preservation and retirement annuity funds. South Africans need to have maintained their non-resident status for 3 unbroken years. So the onus is on the taxpayer. And then SARS needs to be satisfied that a genuine exit has been made. So in terms of this, if you do have retirement funds, ultimately you can't deregister from tax in South Africa, because eventually when you make a withdrawal, you're going to need that tax number in order to report that to SARS, because it's a South African fund. So what is advised is that after the year that you've ceased your residency, you continue to submit your non-resident returns as a non-resident. So you're ticking that box in the wizard form as a non-resident, and provided you've done your formal exit and submitted those returns can be used as proof as 3 unbroken years of your cessation of residency. Okay, that is our understanding for the legislation we read. Like I said, we haven't yet had the 3 years. So once we have had the 3 years, we can see whether SARS is wanting further information to prove those 3 unbroken years of residency. Okay. It is important to understand that any early withdrawal from the fund is going to be subject to a much higher tax rate. And then remember, ceasing to be tax resident comes with that deemed Section 9H capital gains tax event. This would fall within the realm of that, although no actual cash has to be paid across at the exit on these funds. However, there is going to be a liability that is due, and when those funds are eventually drawn, that's when the payment would be made to SARS. But it can be very expensive depending on how old you are when you leave. And then if you do, after the 3 years, if you're still under retirement age, if you're going to do an early withdrawal, you're going to be taxed at the higher rates. Okay. So those who have retirement annuities are going to be the most inconvenienced because they will need to wait the full 3 year period. Members of pension and provident and preservation funds may have access to certain pre-retirement benefits once prior to retirement. And then pension and provident funds do allow for easier access of these funds. Either a pre-retirement lump sum upon the termination of that employment if you ceasing your employment in South Africa and taking up a new employment elsewhere. All right, so that brings us to the end of today's webinar, but we do have time for a question and answer session. The way that we can assist you, and I will put my email address in the chat box, is we can either do an assessment for you if you're unsure of where you stand in terms of your SARS exit and what needs to happen. If you have started the process and it has been declined by SARS, we can assist with potentially why it was declined. If you're happy that you have exited South Africa and you now don't know on which basis, whether it's ordinarily physical or by the DTA, then we can assist with that, or we can just assist with the whole process as well. So there's lots that we can assist you with. I will put my email in the chat box, and then we do have time for question and answers if anyone does have any questions. Okay, let's see. We'll just give it a couple of minutes. Okay, let's see if there's any questions. The chat appears to have been disabled. I can't see your contact details. Let's see. Okay, it seems like the chat is only allowing me. Okay, so it's not allowing me to do a chat. My email address to nope, should be here. Okay, in the case that people can't see my email address, it's Erin, which is ERIN, at Sales Solutions, which is SAIL Solutions, SOLUTIONS.co.uk. So Erin at salessolutions.co.uk. All right, thank you everyone for attending. If you do have questions or you want further advice, then just pop me a mail and we can go through those individually. Thanks everyone. Have a lovely day.